Welcome to the debate. Today we are addressing a core piece of our constitutional framework, the enduring legal scope of the 26th Amendment. This is the amendment ratified swiftly back in 1971 that set the national voting age at 18.
Right. And the central question isn't really about the age itself. I think we can agree that battle is settled, but it's about the power of the text, wouldn't you say?
Exactly. Does the 26th Amendment function narrowly, primarily guaranteeing just that minimum voting age and, avoiding the dual age chaos that cropped up? Or is it actually a broad, proactive constitutional instrument, one that empowers federal oversight to dismantle state election procedures that create disproportionate burdens on young adults today?
A critical distinction.
And I'll be arguing for that broad interpretation. I believe the text and the legislative history reveal that this amendment was intended as a serious, prophylactic constitutional tool, meaning it was really designed to prevent systemic problems and discrimination before they even start, mirroring the intent and the power of the 15th and 19th Amendments to actively protect robust political participation.
See, I'm sorry, but I just don't quite buy that the scope is that expansive. I come at it from a different angle, emphasizing the context of its adoption. While the amendment certainly achieved a vital objective, uniformity of age, I argue its core purpose was really singular, fixing the age limit and avoiding the massive administrative, logistical chaos that resulted from the Supreme Court's, frankly, mixed ruling in Oregon versus Mitchell. We should read it as setting an age floor, not as some kind of ongoing federal permission slip to police every nuanced state procedural rule that might happen to, inconvenience an 18 to 20-year-old voter.
Okay, well, let's start with the language then, because I believe the text itself really signals this expansive intent. The amendment states, and this is key, that the right to vote shall not be denied or abridged on account of age. Now, this phrasing, denied or abridged, it's not accidental. It is lifted almost verbatim from the 15th Amendment, which was obviously designed as one of the most powerful anti-discrimination tools in our entire constitutional arsenal. That deliberate choice of language, I think, signals Congress's intention to provide a broad, potent constitutional protection.
It's definitely powerful language, I grant you that.
And furthermore, the legislative history doesn't just mention setting the age, it explicitly addresses these systemic burdens. The Senate report stated, and I quote, that forcing young voters to undertake special burdens, obtaining absentee ballots, or traveling to one centralized location might well serve to dissuade them from participating, which is inconsistent with the purpose of encouraging youth engagement. So this clearly shows they were worried about burdens, well, not just outright denials, but these subtle discouragements.
Okay.
And early court cases even seemed to embrace this wide scope, particularly when it came to student residency issues. Take Sim v. United States. That case involved a local registrar who imposed these wildly onerous criteria on students, things like requiring them to prove they intended to remain in town after graduation, making it almost impossible for them to register to vote locally. The Supreme Court summarily affirmed an injunction against this practice, which strongly suggests that imposing such special hurdles constitutes an unconstitutional abridgment. The underlying principle, it seems, is that the amendment was meant to nullify sophisticated as well as simple-minded modes of discrimination.
That's a compelling argument, certainly, citing Sim. But I think the timeline of ratification really changes the framing here. The amendment was ratified in record time, less than 100 days. And that incredible speed, I'd argue, was driven less by some sweeping ideological commitment to dismantling all potential youth burdens, and much more by, frankly, pragmatic necessity.
Pragmatic how?
Well, the Oregon v. Mitchell ruling had created a genuine crisis. It upheld the 18-year-old age for federal elections, yes, but it ruled Congress didn't have the authority to impose that age for state and local elections. This forced states almost overnight to implement a dual-age voting system. Imagine separate ballots, separate registration rolls, completely different administrative processes for voters under 21. Senator Bay at the time estimated this would cost states anywhere from $10 million to $20 million nationwide, which was a huge sum then. The immediate priority was resolving that expensive, logistically untenable crisis and achieving uniformity. That, to me, favors a narrow, functional scope. The cost, the sheer administrative nightmare, that was the driver, not necessarily a brand new mandate for ongoing deep federal oversight of every state election procedure. And I'm also seeing, a contemporary judicial environment that seems to favor an originalist baseline when defining abridgment. Look at the Fifth Circuit in the Texas Democratic Party versus Abbott case. They established a test suggesting an election law abridges a person's right to vote only if it makes voting more difficult relative to the baseline right that existed back in 1971.
That 1971 baseline seems quite restrictive.
Well, maybe, but if the baseline right is standard in-person voting, as it largely was in 1971, then courts can more easily distinguish between an actual constitutional prohibition on taking away a right and merely altering what might be considered a privilege or a convenience. The Seventh Circuit, for instance, in Tully v. Okeson, characterized age-based absentee voting laws that maybe favored older voters, as affecting only a privilege to vote by mail, not an abridgment of the fundamental right to vote itself. And if it's just a privilege, the state likely only needs a reasonable justification, not the kind of high bar of scrutiny, like strict scrutiny, that you seem to be advocating for.
I see why you rely on that cost and administrative crisis argument, but doesn't that narrow reading, focusing only on the 1971 baseline, completely undercut the original ambition of the reformers, who deliberately chose the 15th Amendment language? That semantic barrier you're drawing between abridgment and privilege feels like exactly what undermines the amendment's prophylactic, its preventative intent.
Well, it's the line the courts seem to be drawing currently.
You cited the Fifth Circuit's reasoning in Abbott, where they suggested that making voting easier for one group, let's say expanding vote-by-mail access for voters 65 and older, doesn't constitute an abridgment for the younger group because their baseline right, their 1971 right to vote in person, hasn't been touched. But the constitutional problem, I think, arises when states selectively provide conveniences that disproportionately benefit older, maybe more established voters, while simultaneously erecting specific hurdles targeted primarily at young, often student voters.
But the convenience of a mail-in ballot is a benefit, isn't it? Not a fundamental right, according to the reasoning I just laid out. So if the young voters are not denied the original mechanism of voting, the precinct polling place, how is their right truly abridged just because another group got an extra benefit, an easier way?
Because constitutional problems emerge when certain access points are available for some people, but are affirmatively, deliberately blocked for others who face unique structural barriers. Consider the Florida early voting cases. Florida election officials categorically prohibited early voting sites on college campuses, even while they were expanding early voting opportunities across the rest of the state.
Okay, I remember that case.
Amendment, and found it to be, quote, intentionally discriminatory on account of age. The court recognized that blocking that convenience, that specific access point for students, a convenience available to others, imposed a disparate effect that rose to the level of a constitutional violation. The state was selectively reducing access for a protected class in a way that had a real-world impact on their participation. So the denial of a modern convenience, when it is applied selectively and disparately to a protected age group, is an abridgment in practice, even if, theoretically, in-person voting remains open somewhere miles away.
That Florida case definitely pushes back, but it takes us directly into the complicated issue of intent, which I think is probably the greatest practical obstacle to your broad vision, Florida case maybe notwithstanding. You assert that the legislative history implies both the purpose and the effect of election laws are pertinent, drawing parallels to the 14th and 15th Amendments, and this demands we use the intentional discrimination framework the Supreme Court established in Arlington Heights.
Right, the Arlington Heights factors.
Exactly, and for listeners, the Arlington Heights framework requires the court to look beyond just the text of the law. They have to analyze factors like the historical background of the decision, the specific sequence of events leading up to the law's adoption, maybe statements made by legislators, to determine if a racially discriminatory motive or, in this context, an age discriminatory motive was a motivating factor.
Which seems appropriate given the on account of age language.
Well, the framework exists, yes, but successfully navigating the incredibly complex overlap
between proving age-based intent versus purely partisan intent in court, that has proven incredibly difficult.
It may be difficult, but if the text and history clearly signal this parallel to the Reconstruction Amendments, then we must apply the necessary standards. The amendment's designers, I believe, clearly intended for election laws that impose these special burdens on young people to be scrutinized carefully. And as I mentioned, early cases concerning student residency even applied strict scrutiny, requiring a compelling state interest to justify those kinds of burdens.
But let's look at the practical results when courts actually try to apply this difficult standard today. Consider the litigation involving the Wisconsin voter ID laws and One Wisconsin Institute. This case involved restrictions on the types of student IDs that could be used for voting. Now, legislators had indeed made some, let's say, anti-youth comments in the record regarding those restrictions.
Right, there was evidence there.
There was. Yet, the court ultimately found that the primary motivation for restricting student ID use was partisan-driven, largely by the well-known fact that young voters heavily favor Democrats, rather than being purely based on age discrimination as such. Because courts often struggle or perhaps are reluctant to untangle pure malicious age discrimination from what they perceive as just standard political calculation targeting a reliable voting bloc, the 26th Amendment claim ultimately failed in that instance. The reality is, courts seem hesitant to strike down laws based on disparate effect alone, and proving intentional pure age discrimination separate from partisan calculation is nearly impossible in our modern electoral context where age correlates so strongly with party preference.
I think that judicial reluctance simply underscores the need for either Congress or perhaps the Supreme Court to clarify that intentionally targeting youth, even if the reason you're targeting them is because of their anticipated vote choice, still constitutes discrimination on account of age. The protected characteristic, their age group, their status as students, is the vehicle through which the suppression occurs, regardless of the underlying political motivation. If you are targeting students because they are students likely to vote a certain way, you are targeting them because of the characteristic that defines that age group.
That's an interesting distinction, certainly, but as you say, the courts haven't quite bought it yet, broadly speaking. And that judicial caution brings us to the final and perhaps most perilous issue for your broad scope argument, which is the potential remedy itself, the threat of leveling down.
Ah, yes. The leveling down argument.
Judge Hull raised this point very powerfully, I thought, in his concurrence in that Texas absentee ballot case we discussed earlier. If a court does find an age-based violation because a state statute grants a benefit, let's use the example of easy absentee voting for the elderly, say 65 plus. The constitutional remedy might not be to level up and automatically extend that benefit to the younger excluded group. It might instead be to level down and simply remove the privilege from the favored class entirely. If the state argues, look, this benefit is costly, it's difficult to administer, and it's not constitutionally required for anyone, a court might just agree, which actually undermines the overall goal of expanding voter access.
That is a legitimate conceptual concern, I'll grant you, particularly in, let's say, theoretical discussions of constitutional law. But in practice, the concept of leveling down is rarely, if ever, taken seriously in the modern voting rights context. Why? Because the judicial preference overwhelmingly leans heavily towards franchise expansion, not restriction.
Are you sure about that in the 26th Amendment context specifically?
Well, look at the Ohio early voting case Obama for America versus Husted. It's illustrative. There, the state granted an exception that favored military voters with extended early voting hours, but denied those same extra hours to other voters. The court struck down the exception, yes, but crucially, it required the state to equalize access, that is, leveling up, rather than removing the early voting privilege from the military voters. The court basically found that when a state authorized
But wasn't the Ohio case argued primarily under the Equal Protection Clause? That provides a somewhat different legal pathway than the specific anti-discrimination language of the 26th Amendment. When you're dealing with a specific amendment that protects a class that already enjoys the fundamental right to vote, and the state is arguing that the particular privilege in question isn't actually necessary for exercising that fundamental right, I think the leveling down threat remains a more potent legal constraint. If the benefit is expensive or genuinely hard to administer, a court might very well choose the most minimal remedy required to cure the specific inequality found, which could easily be removing the privilege altogether.
I remain convinced that this leveling down fear is mostly a theoretical boogeyman in modern election law, perhaps designed to scare off reformers. The design in the text of the 26th Amendment, particularly that powerful abridged language borrowed directly from the 15th Amendment, intended, I believe, a powerful prophylactic constitutional tool, one meant to ensure robust youth participation and actively eliminate those special burdens we discussed. To read it narrowly, focusing only on the 1971 age floor and that initial administrative crisis, is, I think, to fail to recognize that profound historical ambition and the continuing need to protect young voters from targeted, often subtle procedural hurdles.
I certainly concede that the amendment successfully established the voting age floor, which was a tremendous and necessary achievement. But its application to the complex, often technical, modern procedural laws remains, in my view, severely constrained by the existing legal tests. These tests, as we've seen, struggle mightily to differentiate between provable intentional age discrimination and other motivations, often purely partisan political motivations. And as a result, while the youth vote is protected against outright denial, navigating that murky water between what constitutes a true abridgment versus merely tinkering with the privilege in complex modern election procedures keeps the practical scope of the amendment far narrower, I believe, than its Reconstruction-era counterparts.
So, ultimately, we are left wrestling with the reality that the 26th Amendment remains a somewhat contested or maybe underdeveloped area of constitutional law. How future courts choose to interpret its scope, whether they embrace the historical anti-burden intent I see, or whether they cling to the narrower administrative fix narrative, will really determine its future.
Agreed. It will determine whether it becomes a truly powerful, proactive tool for ensuring future youth participation, or remains essentially a very important historical footnote that guarantees the age minimum but doesn't reach much further into the mechanics of voting today.